Morning, Police Court. I'm Tom Elliott, partner and inferior on behalf of Alexander Davis, who used parallel. I like to reserve 2 minutes for both.
2 minutes.
He used parallel guide wires 3 feet apart, approximately, to climb the TECO power pole in 90 seconds to the top. He did not realize it carried electrified wires. There's no warning sign to that effect. It was near a playground. He suffered severe injuries from the shock. The placement of these guide wires made the pole easily or readily climbable. Plaintiff's experts Gill and Sutterby testified to that. It was easy to climb. That made this accident foreseeable and made the pole an attractive nuisance. There's a few material facts here that precluded the summary judgment. And I think we talk about a lot of things in the brief. I'm trying to go to any of that, but I think the simplest way to look at this is that it was an attractive nuisance because you had the pole there that TECO, let me step back how this got to where we are. TECO relied on its employees' misreading of the National Electric Safety Code that, when correctly read, says that parallel wires 3 feet apart are climbable. That definition is at page 545. At best for TECO, relying on their layperson for a reading of this code is a conflict in the facts, because we have 2 experts that says it is climbable. And we would submit, when you read the definition correctly, as we have done and suggested out doing the brief, and again, looking at page 545, it comes within the definition of climbable. If it is climbable, then what did TECO need to do? Under the same electric code that it wants to rely upon, page 548 and 549, if it's readily climbable, it says readily climbable structures adjacent to places where people frequently gather, playground, shall, it says, be equipped with barriers to make climbing, barriers to inhibit climbing, or posted with a safety sign. All they had to do was put a sign up. If they put a sign up that says electrified wires, Mr. Davidson never climbs this pole. Never climbs. This accident doesn't happen. That's all they had to do. So, our experts say a warning, but our experts say it was climbable. The code says a warning was required. The lay opinion of a TECO employee that they didn't need to post it is at best a question of fact, and this should be reversed. That's the sort of simple way to get where we say this should go back to trial. If this court agrees that the parallel guide wires are different from the dangling single wire in Larissi, and we don't have to worry about that case. I think Larissi is easily distinguishable. They say it's just like this. It's not at all like this. Say single dangling guide wire that a kid climbed up the wire. That's a lot different from climbing up. We've got pictures of the guide wires. If you want to see them in the record, they are at .607 and 8. If you do look at those, the yellow sleeves that are on them now were not on them now. There's like a climbing inhibiting yellow sleeve that's been put on after the fact. Those weren't there then. There are no signs. There were no signs. We have pictures at page 948 of the record that show climbing as a sport. And you look at those things and the kids are climbing on things that are 3 feet apart or so. Okay, so this is a common activity.
Well, Mr. Elliott, it's not a common activity on this record, right? I mean, generally, what this record establishes, kids like to climb.
Yes.
I don't think anybody would dispute that. But there is nothing in the record showing that climbing anywhere near these wires was a common activity, correct?
On these particular wires, no. That's right. But you don't need that, Your Honor. All you need to know is that you've got climbable wires. Under the code they want to go by, you have to sign them. You have to put a warning sign. They didn't do that.
Well, the code says that if the pole is readily climbable, right? And the pole is not readily climbable. It just turns out that the wires happen to be. Correct?
Well, Your Honor, the wires are part of the pole. This is not a single pole just by itself. And the guide wires aren't on most poles. They aren't on most.
No, since I read this case, I've started noticing the guide wires everywhere. So.
Well, there are, it depends on where they are in the configuration of the pole, but they're not, and sometimes it's a single guide wire. That's a different scenario. That's completely different. This is a double guide wire. Under the definition, it is readily climbable. And it talks about a supporting structure. It says readily climbable, a supporting structure having sufficient handholds or footholds, so the structure can be easily climbed by an average person using a ladder, tools, devices, without using ladder tools devices. Not readily climbable, which is what they have to show. Get summary judgment, not readily climbable. And even then, we've got to dispute material fact. But if you're under the code, not readily climbable, says supporting structures, including poles and tower legs, arranged so that there's not less than 2.54 meters, 8 feet, either the lowest handhold or foothold and ground or accessible surface, or the lowest 2 handholds or footholds. Diagonal braces are not considered to be handholds except their point of attachment. And then so these, if you look at the definition correctly, come within the definition of climbable. And again, the NESC is just a guideline. It is not, we're not saying they're automatically liable because they violated it. And they don't get a free pass even if they met it, because we have 2 experts that say this was climbable. And it's foreseeable that when you have it near a playground, and that's the.
Well, and it's not really a playground, is it? I mean, it's a soccer field, it's 120 feet away from the nearest soccer field. I mean, I don't mean to be, pick at these little points, but I think you're overstating your case.
Well, Your Honor, the jury should be the one that decides that. The jury should decide it. The duty question here, McCain is very simple on duty. You have electrified power line. You have a duty. You know it's dangerous. Okay.
You have a duty, and Tico's point is they recognize their duty, and so the electrical wires are 30 feet up. And so I don't think that your argument would be Tico has a duty to create a situation where it is impossible. They have to make it impossible to get to the top of that pole.
You're correct.
And so right, we're somewhere in the middle there. And you had a very, very unfortunate plaintiff who knows the dangers of electricity, but made the wrong decision that this was not an electrical pole, correct?
Correct, because there was no warning that it was not electrified. There was no warning. 16 years old, there's no warning. You put a warning on there, this doesn't happen. Is he comparatively negligent? Sure, that's a jury question.
Well,
and they may convince the jury he's 100%.
But you're trying to get it to the attractive nuisance.
Yes.
And because you want to avoid the entire, was he a trespasser? You want to avoid that whole analysis, which I completely understand. But when we're talking attractive nuisance, you've got a 16-year-old boy. You're gonna trust him with a 2,000-pound machine going 70 miles an hour, but he can't appreciate the danger of clambering up 3 guy wires to the top of a 30-foot pole. I mean, it's a very hard sell.
Well, Your Honor, but Your Honor,
and I know your argument is that sell should be to the jury. Exactly. I totally get it.
Exactly.
But
you don't screen these cases out because you say, well, he should have known better. It's a tall pole, and those are jury questions. They can argue all that. They can argue nobody ever fell from this pole before. They can argue nobody's been electrocuted before. If it were true, but it's not true, as we know from Liberty and the other cases.
How many cases are there that apply the attractive nuisance doctrine to a 16-year-old? I know there's no formal cutoff or anything under the law, but you have to consider your plaintiff and the duty to that plaintiff.
And they can certainly argue that. There's no hard and fast.
Well, Mr. Alley, you seem to be almost implying that the issue of whether or not something's an attractive nuisance is solely an issue for a jury to decide. And that's an overstatement. Would you agree?
Yeah, I mean, we're not talking about 30-year-old like this.
No. I'm going one further. Courts can deem something not to be an attractive nuisance as a matter of law.
A thing, yes. Yeah, sure.
And so the question then is this construction, this condition, as a matter of law, just not an attractive nuisance? I think that would be the way to frame it.
Right, and when you put something that makes it easily climbable, you've made it attractive to climb. That's what easily climbable means. That's why they have that rule in the National Electric Safety Code. And they clearly, despite what they can say how many times they want, they didn't follow, they breached it. These wires were climbable, we have 2 experts to say that, that's a jury question. Now, can they argue he was too old, he should have known better and all those things? Sure. Those are jury questions. If there are any more questions on that, I'm glad to try to answer that. Otherwise, I'll touch briefly on the operational negligence portion. This wasn't just a pole. This was a pole that had wires attached to it, had electrical power surging through those wires. This is just a pole, we're not here.
Well, if it were just a pole and he had slipped and lost his balance and fallen, we may still be here, right? And you would say that he could have climbed up to the top of the pole and they knew it was easily climbable and totally apart from the electricity.
We wouldn't be here on operational negligence. Let me rephrase.
Okay, I'm having a very hard time with your operational negligence
So,
argument.
let me talk about it for a minute, and then
Okay,
I'm glad to
great.
try to answer any questions.
Great.
This accident came because the poles had electrified wires on it. That's Seco's operation, is running electricity through the wires. Okay, that is, and I think the probably closest case to compare this to is the Florida East Coast Railway case, because there the court drew the distinction, said, hey, you're tripping over the spikes that were left on the ground. That's a premises case. But when the train backed over him after he had tripped, that's operational. Here, climbing up the pole, premises. It's not electrified. Get to the top, you get shocked, that's by the operation. And how did that happen? Because they didn't warn, or they didn't put the sleeves on. We're not saying they had to put the sleeves on everyone, but they didn't warn. That would have been the easier thing to do. So here we have a shock from the operation of energized lines. That's operational negligence. I have to try to answer that.
Because he never would have gotten shocked if he hadn't been trespassing. The person who got his legs run over by the train, he was trespassing.
Yes.
But even if he hadn't been trespassing, he could have tripped, fallen on the tracks, and had his legs run over by the train. The negligence was completely independent from the trespass, and that's if he hadn't been trespassing at the top of the pole, he wouldn't have gotten electrocuted. And so therefore,
Right, and
you can't divorce the premises from the asserted negligence.
And if the guy hadn't been trespassing the train yard, he would have tripped over the spikes.
But I'm not talking about a but for, I'm talking about it. They're 2 separate incidences. There's nothing negligent about running electricity through wires. If, for example, one of the wires had sparked suddenly or had been improperly maintained, I mean, maybe, but your argument goes to he wouldn't have been on the premises in the first place. And that's why you can't, that's why I'm having a very hard time seeing this as operational negligence.
Well, he could be on the premises and he's trespassing, just like the guy in the train yard. But if they put the sign up or they put the yellow sleeve up that's on him now, you can see if you look in the record, he doesn't climb.
But then he's not.
He's still trespassing. He's on them. He's by the pole. He's still trespassing, but he doesn't get hurt by the operation, which is and he didn't get hurt by climbing the pole. He got hurt by the electricity, which is what their operation is.
Well, it kind of depends on how you phrase that, right? I mean, as I recall, he has kind of a blackout, right, as to what happened preceding the finding. He did fall over the 25 feet.
Yeah.
Or far as, I mean,
But he
his
didn't lose.
injuries, I mean, yes, he was electrocuted, but falling that 25 feet didn't help.
No, but it didn't cause the electric burn that amputated his arm. So, I mean, yeah, and again, they want to get in front of the jury and say, don't assess us for the fall, just assess us for the shock. That's an argument they can make. But we're talking about a lot of jury arguments, a lot of jury arguments. Okay. And again, so's the age thing, they can argue that. We've got 100+ years of law, and there's no case that says 16 is too old.
Yeah, but there is older law that says it's confined to young children.
Well,
I mean, the original Florida Supreme Court case that brings this in from the restatement defines it as such. The duty is vis-a-vis young children.
Your Honor, Larissa was 14 and a half years old. And this court's case says nothing about, hey, we're knocking him out because he was too old. So, and I would suggest attractive is a relative concept. 2 or 3 year old kids, this wouldn't be attractive. You gotta worry about them going in the water. They're attracted to water as a general rule.
I don't know, I've seen some 3-year-olds in my neighborhood that do love to climb.
Yeah, but they're not gonna, they wouldn't try to climb this, I think. I mean, be too far apart. Maybe they would, and again, you know, but the point is, as the kids get older, as we see, climbing is much
The
more.
capabilities
Yes,
get bigger.
yes, and then you need to put the warning up. This is a simple case to address this problem. And they didn't do it. You don't get one free electrocution. That's not the way this works. Was there any further questions? We actually reverse the summary judgment, let the jury decide the jury questions. Thank you.
Thank you. You've got your 2 minutes left.
May it please the court, my name is LB Martin, I represent Tampa Electric Company. We're asking this court to confirm the summary judgment entered by the trial court. I want to start with this readily climbable argument. My first point on it was, this was not raised to the trial court, that we violated Rule 217, this unique definition proposed by appellant's counsel, so we would say it was waived. The first time, in the initial brief on page 19, Mr. Davidson says that the only relevant category for this appeal with respect to legal foreseeability is the 4th category of Smith. The 2nd category of Smith, which talks about violation of the code, was not addressed. It's not until the reply that really this argument that we violated Rule 217 is raised for the first time. So we would say, because it wasn't raised on appeal, it's waived. We would have made arguments to the trial court about why the NESC has other provisions that allow this type of guide wire construction. And within the NESC itself, it defines readily climbable structures, and it includes a not readily climbable structure as guide wires. We also will note that we would have included in our briefing the proposed order submitted by Davidson's counsel to the trial judge stating that they are, quote, not pursuing any action based on code violations.
Well, I think they just mean readily climbable in terms of you've got a kid and he can very easily climb up it. I mean, in terms of it making it an attractive nuisance.
Right, and I'll address that. That's my next point, Your Honor, is that the attractive nuisance doctrine doesn't apply. I mean, ultimately, this point about Rule 217 is moot because Mr. Davidson is a trespasser to whom no duty is owed except willful wanton conduct of which there's no evidence. And the attractive nuisance doctrine simply doesn't apply. We have the 2nd DCA case in Laracy, which says that it does not apply to a power pole, even though there's a means exists to climb to the top. The court wasn't specific as to finding that it was a dangling service wire versus a guide wire. Actually, if you read that case, it's interesting. They know that that pole did have a guide wire and it had a dangling service wire on top, and there was conflicting testimony as to whether that service wire was dangling at the time before the accident. But the court ultimately says it doesn't matter what he climbed, if he climbed the guide wire or the service wire, because the fact that the power pole has a means to climb to the top is not an attractive nuisance as a matter of law. And I would just like to point out that Mr. Davidson's arguments about attractive nuisance ignore one of the key elements, which is he's talking about the climbability of the pole and the guide wire, but he fails to address the fact that Mr. Davidson, because of his youth, wouldn't realize the risk. As you've already pointed out, the Supreme Court in Richmond states that the attractive nuisance doctrine only applies to those of tenderest of age. Anyone above tenderest of age, which is Mr. Davidson, he's an above average 16-year-old, above average intelligence 16-year-old. He admitted he knew what he was doing was dangerous. He called it a reckless act. He called it an unsafe act, climbing 30 feet into the air. He knew that he should have known that the power lines were energized because he admits when he got into the soccer field, in the back, the Northdale substation was energized, and any lines coming out of that substation would be energized. The particular pole that he climbed was the 4th pole from that substation. He admitted if he had just simply looked to see that this line came from that substation, he would have known it was energized. We would submit it takes almost barely any additional effort for him to read a sign than it would have been to simply look to see that this line was coming from that power pole. So the attractive nuisance doctrine, despite the fact that there's a binding case already on point, Laracy, it wouldn't apply because there's no evidence to show that he didn't already know of the danger of what he was doing, right? So that's why we say the attractive nuisance doctrine is inapplicable here. And because he's a trespasser, ultimately, we don't owe him a duty of care. I want to address the operational negligence theory. So in order for the operational negligence theory to apply, this is addressed in Hicks and Maldonado, there's two elements. The trespasser has to be known at the time of the accident, and there has to be allegations of negligence divorced from conditions of the property, as you were pointing out, Your Honor. And so Mr. Davidson doesn't address the first element there, that he was a known trespasser. He was alone at the time he climbed. No one knew he was climbing the pole. There's no evidence that we had knowledge of witnesses. No recurring pole climbing activity at this pole at the Northdale Soccer Park. No constructive knowledge of, say, broken guy wires, scuff marks, anything that would indicate anyone's doing any recurring pole climbing activity on any of Tampa Electric's distribution power pole system. And because of that, because he's an unknown trespasser at the time of his trespass, the operational negligence exception simply does not apply. It also doesn't apply because the second element, which has to be unrelated to conditions of the property. Now, Mr. Davidson was hurt by the very power pole that climbed. His arm contacted the line. He fell 30 feet to the ground below. He's alleging, his core claim is that we failed to keep him off our property. And so he can't bring allegations of negligence independent of our property because he was hurt by the property, on the property, by dangers that were inherent to the property and our alleged failure to keep him off the property. And he admits as much in his briefing when he's talking about the second independent reason we have for summary judgment, which is this act was not legally foreseeable, which is he's citing multiple times the existing conditions on the property which make this act foreseeable. But by making those arguments, he's admitting it's not an operational negligence claim. With respect to the argument that these are all jury arguments that the jury needs to decide, I respectfully disagree. Legal duty is always a legal question. It's always for the court. That's what the Smith case says. Even if there's some factual inquiry that's required, what duty a power company owes is a legal question that the court can decide. We cited 4 cases where summary judgment was granted for having no duty. That's the Smith case, the Richmond case, the Bigland case, and the Rice case. And I will also touch on one other thing that opposing counsel stated, which is the warning, that all Tampa Electric had to do was warn of something. But the question is warn of what? Because Mr. Davidson admitted he knew climbing 30 feet into the air was a risk. It was a risk he was taking. It was an unsafe and a reckless risk. He also admitted he knew the power lines were energized coming from the substation. He simply just didn't look, which is almost the exact fact pattern of both Richmond and Rice, where the plaintiffs saw the power lines in the distance. They simply just gave them no mind and didn't consider them. And the Richmond court, the Florida Supreme Court stated, well, we're not going to require power companies to establish warning signs and guards because the inherent danger of electrically energized wires is well known to all those except of tenderest age. And Mr. Davidson is not of tenderest age. And so in that case, the court said it was the plaintiff's responsibility to assume the power lines 30 feet in the air were conducting electricity, not the power lines' duty to warn people on the ground. And regarding, again, just this duty element, I believe that Mr. Davidson is confusing duty and foreseeability as it relates to proximate cause and as to duty. And McCain,
In fairness, that's a tricky
I
concept.
agree with you, Your Honor, yeah.
A lot of folks do.
Yeah, McCain is clear though that one is a fact question, and one is a legal question. And I'll say that if you look at how Mr. Davidson describes duty in his initial brief, which is on page 20, he says the legal minimum threshold for duty was met because Tampa Electric was transmitting electricity and knew it was dangerous to anyone who came in contact with it. So he's suggesting the standard that anytime there's an accident, there was a duty to prevent that accident. And that's clearly not what McCain or
I think
Smith.
he might be suggesting there's a foreseeable zone of risk, right?
No, not based on how he's defining duty. It's more, he's defining foreseeability as a
Well,
possibility.
McCain uses the term foreseeable zone of
Correct.
risk.
Correct, Your Honor. Yeah, and that's the error, I think, in how plaintiffs are describing the duty, is they're
I mean, they
reading
had
out
one
foreseeability.
episode in 100 years, right?
That's correct.
So is
There's
it still a jury question if it's foreseeable?
No, Your Honor, we would submit it's not, because as Smith describes, you need to have existing conditions or recurring activities that give rise to this legal foreseeability. And we simply just don't have that in our case. And it's not just a matter of not having prior accidents. There's no prior climbing activity. There's no reports. There's no safety bulletins. There's no constructive notice, worn paths to the poles, anything like that. There's just no indicia of evidence anywhere that people were climbing on Tampa Electric's power poles. And Your Honor, I'll just end with this. Ultimately, Mr. Davidson is a trespasser. He admits he's a trespasser down below. He's not challenging that status on appeal. He's merely challenging the relevancy of that status, whether he fits into the operational negligence exception or the attractive nuisance doctrine. We submit he doesn't fit into either of those. We briefed that and we'll rest on recent those arguments. But ultimately, the legal foreseeability is moot if he is a trespasser to whom no duty is owed. Thank you. Unless there's further questions, I'll.
Ms. Delegate, you asked for 2 minutes on your phone. Is that enough? All right, probably, you had 2 more minutes above that.
Okay, thank you. Yes, Your Honor. We talked in our brief about the foreseeable zone of risk, and if you look at page 504 of McCain, it says there can be no question but that Florida Power has the ability to foresee a zone of risk. By its very nature, power generating equipment creates a zone of risk that encompasses all persons who may foreseeably come in contact with that equipment.
Including trespassers.
Including trespassers, including people who are attracted to something because it's an attractive nuisance. So they have a duty that the duty foreseeability is a minimal concept, as they say in McCain. Foreseeability for proximate cause, different. They can argue, jury question. They can say, TECO had no idea anybody was going to try to do this, even though they have an incident where somebody climbed a single dangling wire 50 years earlier. They can still say 60 years earlier. They can still say we had no idea this could happen. The Richmond case is not an attractive nuisance case. The business about the quote about tenders of age is a general statement about people know electrically energized wires are dangerous. The guy is a pilot. He had been a pilot. This is an adult. Richmond has nothing to do with attractive nuisance. Nothing. And what it does say is it says no need to digest and correlate the cases. Safeguards such as warning notices depend largely on the facts of the individual cases. And here you put easily climbable guide wires on a pole next to a soccer field, which is the playground for adolescents. It's playground equivalent, right? They should have seen that that was a possibility. The jury should be entitled to determine that they should have seen. As far as climbability goes, that issue was in the trial court. We have 2 experts that say this pole was climbable. So I don't care what the NESC says. I think they're misreading it. If you go back and look at our brief and go through it.
Ms. Delegate, you've used the 2 minutes, but since you didn't use your retired,
Thank you, Your Honor. And that's,
you want to finish up?
that was it. I was going to say, Larissy is clearly distinguished.
All right.
Thank you.
Thank
We would ask you yours.
Thank you, gentlemen. Very interesting. Have a great day. We'll be in recess.
All rise.
Sir.